So welcome everybody to the final CLAANZ webinar of 2025, and it's also the final CLAANZ webinar in our 2025 Key Cases series. I'd like to start by acknowledging the traditional owners of the land where I am, which is at the University of Sydney, the Gadigal people of the Eora Nation, and I'd like to pay my respects to elders past and present. I'd also like to invite all of you online to reflect on the traditional owners of the lands where you are dialing in from. So today's webinar, as you'd all be aware, focuses on the very recent Supreme Court of Queensland decision of the Presbyterian Church of Queensland and Catalyst Carina. And we are very fortunate to have three excellent speakers today who are all very experienced practitioners in not-for-profit and charity law. And so I'm going to introduce each of them first in order of which they'll be presenting. So our first speaker is Chris Mills. Chris is a director at Neumann and Turnour lawyers in Brisbane. And Chris is really going to begin by giving an outline of the case itself. And if anybody's actually read the case, you'll see that there are a lot of facts. There's a lot of facts to get across. So Chris is going to help us to understand those facts and put them in some sort of chronological order for us. Then we're going to have analysis by both Elizabeth Shalders, who is a special counsel at Mills Oakley, and Anne Robinson AM, who is the founder of Prolegis lawyers. And Anne's based here in Sydney. So we'll also, just so you all know, we'll save time at the very end for the Q&A. So we'll have the three presenters in order, and then Q&A at the end. So, but you can feel free as they're talking to put questions into the chat, and we'll get to that at the end. So let's start first with you then, Chris. Thank you.
Afternoon, everybody, and morning for those for whom it's still morning. There's quite a bit in the judgment, as Natalie said. I think the way that it's being dealt with factually is on an issue-by-issue basis. So I've come in to try and order everything to the extent possible in the time we have in a chronological basis so that you can get a bit of a sense of what the deals were, what the background to the deals was, and why things ended up as they did. So starting a long time ago in 1863, a group of Presbyterian congregations in Queensland got together to form a church. Moving on from that, once they got together, other congregations joined them and they began to acquire property. So they incorporated a property holding entity, which was a letters patent entity under the Religious, Educational and Charitable Institutions Act of 1867. That comprised three office holders of the church body as members. There are no directors. We can discuss that later as needed. By about 1929, the church had grown a bit in size and it was beginning to receive property from bequests and other donors. Among that property was some aged care facilities, or some properties that were used for aged care. So we can see at that point it's going beyond just being church properties and moving into other charitable space. If we fast forward a lot longer, come 1998, 1999, the church is starting to restructure the way that it delivers these services. It puts together a body called Prescare. Everything previously had been administered by a Department of Social Mission. It puts together a body called Prescare. Prescare has its own tax structuring, its own accountability structure. It has separate accounts, separate books. It goes to get registered to be a deductible gift recipient, all of that sort of thing. So it keeps everything fairly separate there. It also ends up acquiring a fairly big team by the end of things to work on things. Around 1999 as well, some money was used to purchase some land at Carina. Part of that block had a church put on it. The rest of it was turned into a residential aged care facility that was under the administration of Prescare. In 2014, Prescare acquired a license from the Commonwealth, or the relevant Commonwealth department, to have a residential aged care facility in Townsville with 100 beds. In 2015, it bought some property up in Townsville to start work on that facility. While it was going through that process, it got some modelling done by its auditors and advisors that suggested that it would be far better off operating a property that it owned rather than coming in as an operator of property that somebody else owned for that purpose. In 2016, it had a number of unsuccessful attempts at getting bank finance to be able to build the facility on that land. And then in 2017, the Prescare executive turned to Catalyst for some assistance. So Catalyst at that time was a new model, and as the negotiations unfolded, it comprised the following. Catalyst was to buy the land off PCQ. Prescare would lease the land back from Catalyst. Now, Prescare obviously being the corporate entity behind Prescare is still PCQ. It's just the structure within it. So Catalyst would fund the construction of the facility. PCQ had control over the construction, so it designed and put the facility together that it wanted on the land. Prescare didn't contribute any funds at that stage. Prescare would then operate the facility, and that would include all of the operating costs of the facility. So the contributions by Catalyst at that point had finished, and then once the facility was open and operating, it was all to be borne by Prescare. And then the deal also included various stages at which the property could be bought back from Catalyst by PCQ. Catalyst was to obtain funding for all of this from investors, which included some superannuation funds. PCQ's obligations included the payment of rent and outgoings, obviously the operating costs, and an amount described as capital installments to repay the capital outlays by Catalyst in doing the construction work. Negotiations took over 6 months. Prescare was represented by its executive team, in-house lawyer Secondi from KPMG. It was also externally advised by KPMG and external lawyers. The sale contract for the property settled on the 22nd of December 2017. So that's when Catalyst, or the Catalyst entity in that particular deal, received the property up in Townsville. Prescare entered into a similar agreement a few months later concerning land at Corinda. So there was a different Catalyst entity set up for that one. They're all sort of under the same umbrella, obviously. But it acquired land that PCQ held at Corinda for the purpose of developing an aged care facility at that location. Same deal. PCQ or Prescare was to oversee the construction, and Catalyst was to pay for it, and then you'd have the repayments afterwards and the loan payments. Work started on construction of the Townsville and Corinda facilities through 2018. Meanwhile, the Prescare executive team sought some further commercial advice from KPMG because it had received notification from its banks that it was in breach of the terms of its existing loans. And there's a separate process then sort of commenced there where we can see KPMG giving advice to the Prescare executive team, which is along the lines of hold your horses, slow things down a bit, develop a proper plan. There are reasons that the bank don't want to deal with you. You should, take a bit of time before you enter into expensive deals like this. Undeterred, the Prescare executive team began negotiating the sale and leaseback of a third property, which was the Carina property, upon which it already had an aged care facility. That one wasn't quite the same arrangement. They were just working on the basis of a lease only for that one because there wasn't construction required. Catalyst advanced a loan to Prescare at that point as well that allowed it to clean out all of its current bank loans at that stage. When the settlement of the Carina property was completed, it used the money that it had raised from that sale to pay out the Catalyst loan. And that was in 2020. That was before 2020, sorry, but by 2020, it became apparent that these deals were expensive and that Prescare wasn't going to be able to meet its obligations under the agreements. They began to negotiate with Catalyst. Catalyst agreed to a forbearance for 12 months while further negotiations carried on. And that is a forbearance on the payment of the amounts owed under those agreements. Where we end up with this as well is the Townsville facility was completed and began operating, so people were moving in. Carina was never completed and operated by the time all of this happened, and Carina was already an operating facility. By May 2021, it became apparent that the deals that had been struck up to that point were no longer going to be effective. On the 12th of May 2021, the agreement was terminated and PCQ applied to appoint receivers and managers because it didn't have the assets available to readily meet the debt. Once the receivers were appointed, they oversaw a process for the sale of the facilities, which resulted in proceeds of about $100 million, and the net proceeds all went to Catalyst. The Catalyst parties then commenced proceedings to recover the amount of their equity payments. That there was a way under the agreements that the equity payments would be totaled up and become liable in the event of breach. So they sued to recover the equity payments. The receivers said, no, you can't have them. There's a whole bunch of reasons for that. So they defended the proceeding. They put on counterclaims, and in respect of the Carina property, which you'll recall didn't have AFIPs because it didn't have construction, they commenced proceedings against the Catalyst Carina entities. In outline, the receiver's case was this. PCQ held the property as trustee for a Prescare Constitution Trust. As trustee, the PCQ lacked power to enter the agreements or breach the trust, or breach the terms of the trust upon which the property was held. Each agreement was imprudent, hazardous, and wholly unsuitable for the trustee of a charitable trust. An appropriate degree of conservatism and restraint was not exercised by PCQ in entering the deals. As purchasers of the trust property, the Catalyst parties were required to ensure themselves that the transactions were beneficial to the permanent and lasting interests of the PCQ, and they didn't. The Catalyst parties knew or ought to have known that they were dealing with a charitable trustee in entering these agreements, and that the deals breached the trust. So the allegation is that they knowingly procured a breach of trust. It was unconscionable for the Catalyst parties to enforce the equity payments. Two reasons. The first is because of the manner in which they negotiated the agreements in the first place. So the allegation was that they had PCQ at a disadvantage. And secondly, because they had actually basically been made whole from the sale of the proceeds, from the sale proceeds of the properties, and that there was no need for them to recover the equity installments by that stage. In summary, the court found as follows. Firstly, PCQ held the property as trustee, but there was no separate Prescare trust. While the Attorney General, who had joined the proceedings as a protector of trusts, had advanced a case that the church existed solely to advance religion up until around the 1929 mark, when it began to acquire those properties. The court held that the general purposes of the church included the care of the aged and infirmed. Sorry, just to get that off. The Attorney General was trying to say effectively, this is just a religious body up until 1929. It begins to operate in this other space, so there's an enlargement of the trust purposes, and therefore the property that was held for those purposes must be held on a separate trust. And the court says, no, this is all within the general purposes of the church. There's no caveats or qualifications around religious motivations or anything like that. The church was simply able to use the assets it held for general purposes to care for the aged and the infirmed. The second finding was there was no breach of trust, and I think Elizabeth will elaborate on this a bit further. Third, while the trustee may have a duty to ensure that assets it invests for preservation are not subjected to hazard or speculation. These were not investments. This was the use of assets to pursue its purposes. So we're not trying to preserve the value of the property here in entering these deals. We're actually trying to use the property. And because of that, there was no duty to avoid speculative or hazardous investment placed upon the PCQ. Nextly, the purchaser principle didn't apply. That's the one that says that the purchaser has to inquire about whether the deal's in the lasting interest of the church, because the properties aren't a specific gift or bequest left for a particular purpose. So, for example, they weren't for the construction of a lasting edifice or for some kind of commemoration of a legacy or something like that. They were actually resources to be used to meet needs. So there was no requirement for the purchaser then to inquire beyond that and ascertain whether these properties are going to be held into the future or not, or whether the proceeds of sale will continue to be used for that purpose. There was no evidence of any dishonest or inappropriate dealings by Catalyst. In fact, quite to the contrary, Prescare seemed to be very well advised and resourced in entering the dealings. The consequence of all of that is that Catalyst is entitled to its money, its AFIPs. There was a further amount that it didn't receive that was for occupation rent, because there was a period of time in which they stayed in the properties so that they could facilitate the orderly sale that was on terms beneficial to the Catalyst parties. So that there was an amount that they didn't get there, but otherwise they were entitled to the AFIPs, which is a very substantial amount of money, in excess of $30 million.
Thanks, Chris. Thank you for that introduction and that chronology. Let's go straight to Elizabeth then, who I know has some slides to share.
Good afternoon. You all see my slides? We're good? Okay. I want to look at this case through the lens of what can we learn about the duty of care and diligence from this judgment. And when I talk about the duty of care and diligence, hold on, slides aren't moving. Okay. When I talk about the duty of care and diligence, there are various aspects or equivalents of this duty that appear in multiple places in law. So obviously under the Corporations Act, one we're all familiar with, directors must exercise their powers and discharge their duties with a degree of care and diligence that a reasonable person would exercise if they had the same responsibilities and circumstances. There's an equivalent duty of directors under the general law. There's also a duty on trustees, which is that trustees are obliged to act with the care of an ordinary prudent business person. And then there's an equivalent duty in the ACNC. So with that context, let's look at these facts in this case and how these duties unfolded. As Chris mentioned, there were three different properties here: Townsville, Corinda, and then Carina. I'm going to focus in on Carina because this transaction happened last, and by this stage, PCQ, as that's the name of the shorthand for the corporation, had some pretty explicit advice about the transactions. In 2018, KPMG said that a sale and leaseback may provide a short-term fix to the issue for the financing predicament, but the high cap rate is likely to only delay the issue and could cause additional cash flow pressures in the future. KPMG advised that the sale and leaseback in Townsville is on particularly unfavourable terms to Prescare. They said Prescare should immediately discontinue any future sale and leaseback plans. They said sale and leasebacks are simply another form of debt provided by an alternative financer and is provided with substantial debt servicing costs, and that these future obligations are going to place ever increasing pressure on the Prescare financials and in due turn will require increasing support from the church. And ultimately, they said continuing to pursue Corinda when finances are in the current state demonstrates an inability to recognise the issues facing Prescare. And in addition to this, there was an email sent that the judge said referred to safe harbour provisions, which is sort of like KPMG raising a bit of a red flag around solvency. So I'm reading this judgment thinking, how can you have this situation and then not have a finding of breach of duties of care and diligence? Everyone accepted that office holders have fiduciary duties, but as Justice Bradley pointed out, that says nothing about the scope or content of their duties. The office holders were obliged to act with the care of an ordinary prudent business person and inform themselves of matters which are relevant to a decision, including advice from appropriate expert advisors. But there was no finding that they breached this duty. And in fact, in paragraph 378, Justice Bradley finds that the relevant General Assembly boards and committees were drawn from the elders and members of the church. They made decisions for the church in pursuit of its charitable purposes. They cannot be held to a standard required of company directors. So when I read this, I was a little bit stumped. It doesn't seem to fit with conventional wisdom, and I don't think a lot of regulators would accept that there is somehow a lower standard for people who are office holders of a statutory corporation. So I've gone on a journey through this case to unpick what are the differences between company director and trustee standards of care, and how do they apply in the case of a statutory corporation. And when I actually began to work through the detail, it made a lot of sense. So I'm going to try today, in the short time available, try and walk you through the journey I've gone in understanding this case. And it begins with understanding a little more around the structure of the Presbyterian Church. So the starting point's the General Assembly, which is the really authoritative decision-making body that's representatives, I think, of the various churches. It's all religious adherents, and it's a key aspect of Presbyterianism that the General Assembly, being this large, organised, large body, is the key decision-maker. This General Assembly then delegates to various boards. In this case, the main board that was concerned with these transactions was the Pres Care Board, and it oversaw all the Pres Care activities, and of course, these were all unincorporated entities. The finance and the property boards also had some input. And Justice Bradley describes these boards as drawn from the elders and members of the church. In turn, those boards then hired experienced executives. Once a proposal had made its way through the executives through the relevant boards, it was then given to the office holders of the corporation to execute on behalf of the corporation. Now, as Chris has said, these are the office holders. They're not directors. He says they're members, but they're the people with the power to execute and enter into transactions on behalf of the corporation. But of these three office holders, they held their office because of their significant positions within the church, and only one of them, that was the treasurer, had any financial expertise. But what you find when you start to look at the executives is there is a lot of expertise and experience. So the CEO, Greg Skelton, had 20 years experience in aged care. He had a CPA with a degree in business. He had an MBA in strategic management, and he was a member of the AICD. And we had Peter Lynch, who was the chief financial officer. He was a chartered accountant with more than 35 years experience. He was an auditor. He had previous roles as director of finance and CFO in other organisations. He's worked not only in the NFP sector, but in the business management and tax services. And he led a team of 10 financially qualified and literate accountants. Mr. Playford was the financial controller, and he had significant experience in financially modelling commercial transactions. And Mr. Bozell, the coup, had extensive aged care industry experience. Now, when you read through the judgment in more detail, what you actually begin to notice is that really frank advice from KPMG in 2018 was given to the executives. There's no evidence it actually went to the Pres Care Board, the Finance Board, the Property Board, or the office holders of PCQ. It looks to me from the judgment that the executives may have held on to this advice themselves, and I can speculate as to two possible reasons why. One is it does look from the judgment as though the catalyst option was the preferred option of the CEO. But the second is that the advice from KPG also included some comments that were disparaging of the leadership. So maybe that's why they didn't want to pass it on. Specifically, KPMG told them that banks wouldn't refinance them, wouldn't do refinance for them until there was a change of leadership. But in any event, it's very clear from the judgment that there was a very strong reliance by the relevant decision makers at Pres Care and the office holders and the boards on the executives. And Justice Bradley stated, there's multiple references through the judgment, but I've cited one of them there, the corporation relying on the advice of the experienced Pres Care executives contracted with the catalyst parties. Now, that's not to say that there was no one checking what staff did at board level. And this is where the evidence of Mr. Harris becomes relevant. Mr. Harris was the Treasurer of the General Assembly. He was the Chairman of the Finance Board. He was an ex officio member of the Pres Care Board. He was a Chartered Accountant and Registered Auditor. And he was the former head partner of the Gold Coast office of KPMG before he retired in 1996. So by my calculations, he was around 87 when these transactions went through. Justice Bradley was impressed by Mr. Harris. He said he thought that Mr. Harris was an astute and careful person. And it's clear from the evidence that Mr. Harris evaluated the different options before them and seriously engaged with weighing the costs and the benefits. And after receiving and considering various models and advice from executives, Mr. Harris concluded, I am now comfortable that this is PresCare's best financing option. It seems to be financially viable. Mr. Harris also gave evidence that the PresCare board understood the importance of economies of scale and took opportunities to increase the scale of their aged care facility operations. And there was some other evidence in the case that sort of said, look, the PresCare board had received evidence that the older facilities were not making a profit, they were loss-making, but that the newer aged care facilities would be profit-making. So this was part of a diversification strategy to help their profitability position. So very clearly from the facts at least, Mr. Harris informed himself and took the appropriate steps to exercise care and diligence. As for the rest of the board, we had this finding by Justice Bradley to grapple with. Justice Bradley has found there may have been some honest blundering and carelessness by less experienced or qualified individuals, content to act on the recommendations of those more experienced or qualified. Some of the PresCare executives may have adopted ambitious plans. Others, including members of the PresCare board, the finance board, and the property board, may have assumed those with the plans had the wherewithal to achieve them. The church governance processes operated. There was no single decision maker. So I read that and I think, how do we reconcile this with the standard expected of company directors? Is there really a different standard here? And when I started to process this, there were three things that I think when I'm doing this comparison between the position of trustees in this context and position of company directors, there are, I think, really three important points that I'm going to take you through. Number one is actually looking at what the standard is for company directors and acknowledging that it varies. Number two relates to a defence that's available for company directors. And three, I think are some really important personal liability considerations. So I'll talk you through those 3 points now. If we look at the first issue, and that is what's the actual standard for a company director, that standard is going to vary according to the nature of the business that's carried on by the company. So in the opinion that was produced for the Australian Institute of Company Directors by Michael Hodge KC, he said that there will be a range of circumstances taken into account in assessing whether a person is exercised appropriate care and diligence. And these include all of the relevant commercial and other circumstances of the company, including, without seeking to be exhaustive, the type of company, the size and nature of the business it carries on, the terms of its constitution, the composition of its board of directors, the competence of its management, the competence of its advisors, and the distribution of responsibilities within the company. So the standard expected of a company director under Section 180 of the Corps Act is the standard of a reasonable person judged by reference to the corporation's circumstances. And so if we're thinking about our company director case law, we have to remember it in this light. And if we think particularly of the ASIC and Healy, which is sort of known as the Centro case, and really the big one for saying you can't just rely on staff, you can't just rely on your auditor, you can't just rely on other people. When we think about that, the thing we've got to remember is that in Centro, their core business was property development using bank loans. So they were expected to understand the reporting of those loans in their financial statements. Here, the core business is actually being the Presbyterian Church. So I think this is quite relevant. I think this is why the judge really focused in on whether the church processes were followed. And it's why it's so significant that there were various boards and groups of decision makers within the church that all signed off on this. So if there's a general principle that equity imposes duties where there's powers, and the powers of the office holders of PCQ were maybe less than those of directors because they're dispersed through these different boards, it makes sense of the standard that the judge applied in this case. Ultimately, the judge made the finding that the corporation sold the Townsville and Carina land to the relevant catalyst parties, leased that land and the Carina land, and applied other property to meet its obligations under the transactions with catalyst parties for the charitable purposes of the church and in accordance with the church's constitution. The evidence did not show that in doing so, the corporation acted other than in good faith, responsibly and reasonably, and exercising the degree of caution expected of a trustee for property held for such charitable purposes. Now, the second point I want to draw out in this comparison is that under the Corporations Act, there's also the Business Judgment Rule and there's Section 189 that provides some protection for directors. And I do wonder that if you actually looked at how Justice Bradley reasoned through the decision, I almost wonder if you get to the same outcome in practice. So Section 189 of the Corporations Act provides for circumstances where a director relies on information or professional or expert advice by staff who are competent and reliable in relation to the matters concerned, or they rely on information from another director or a committee of directors on a matter within the scope of their authority. And where a director relies on that information or advice and they rely on it in good faith after they've made their own independent assessment of the material, they'll be taken to be acting reasonably. So given that the test for care and diligence depends on reasonableness, this defence in Section 189 is quite helpful because it provides that a director is going to be found to be acting reasonably if they're relying on staff or a committee or other directors who are expert on a particular topic. And in terms of what is within the scope of that independent assessment, the Hodge opinion says that independent assessment requires that the director considers the relevant information or advice, which may involve listening to colleagues in a board meeting and or reading a briefing paper or advice where the information's on written form and assessing it, bringing their mind to bear, such as they bear on the issue using such skill and judgment as he or she may possess. However, the type of independent assessment required may vary according to the director's knowledge of the company and the complexity of its structured operations. So it makes me wonder if in practice, the outcome that we arrive at is actually the same between the Corporations Act on the one hand and equity on the other. So if we overlay that 189 test over the actual facts that we have in this PCQ decision in a hypothetical sort of exercise, we might arrive at the same outcome, because Justice Bradley said that the office holders acted honestly, they acted in good faith, they complied with their constitution and the church processes. They relied on the executives who were qualified and experienced. The executives recommended these transactions. And even Mr. Harris, who analysed all the numbers, came to the view that this was the best option. And there was, at least in principle, a strategy around diversification that made sense, even if the numbers didn't work. Final point I want to make about comparing the differences between company directors and trustees here was that when we read this judgment, we should bear in mind the differences in powers that trustees have versus non-trustees and the consequences for breach. So if there is an entity that is a trustee, but individuals, or whether it's directors or members or office holders, when I call them, of a corporation that's acting as trustee, they will only have power to do what the trust instrument or law confers upon them power to do. So they cannot sell or mortgage property unless, for example, unless there is a specific power to do so, which is very different to the situation of a company that's not acting as trustee, which has all the powers in an individual subject to limitations in its constitution. So it is a lot easier for a trustee to be found to be acting outside the scope of its powers. And the consequences of that can be breach of trust, which can result in personal liability for directors, either under Section 197 of the Corporations Act or under the terms of trust, if indemnity for breach of trust is excluded, as it often is in many trustees. There'll be an exclusion of indemnity if you've breached the terms of the trust. So before we rush to say anyone acting as trustee has breached their duty in terms of being a prudent person, we really want to be sure about the standard that we're setting. And this is not just for statutory religious corporations. This is really for any organisation acting as trustee. And I think if we want to start finding that directors of corporations are personally liable in this situation, it's a really huge disincentive for people to volunteer and contribute. And I think what we'd find is that the people who are qualified and experienced enough to understand these risks aren't willing to put their hands up. And it's the unfortunate but well-meaning souls who don't know the risks that get caught. So I can see much wisdom in Justice Bradley's approach in setting the standing where he did and finding that the office holders had acted with the prudence of an ordinary business person. Thank you.
Thanks very much, Elizabeth. I think you can stop sharing.
Yeah.
And we'll hand it over to Anne.
Yeah, thanks, Natalie. Gosh, this is interesting, isn't it? I'm actually going to take us up in the helicopter a little bit. As those of you who know me, it's always going to be the case. But I want to ask 4 questions. And the first question is the underlying set of circumstances in this case just a Queensland thing? Is it a purely Queensland thing? Because we're talking about a letters patent entity under what we all call as the Recce Act. Chris introduced that bit of legislation at the beginning. Is it just a Queensland thing? Is it uniquely Queensland? And I'd say yes and no. Letters patent entities are a uniquely Queensland thing. However, there are a lot of nuances, and I think we need to understand this if we understand some of the subsequent questions around, well, what is the Constitution and where do you find it and how do you know what rules apply? So that's what I'm going to be looking at. It's more of a governance question. Churches historically have been structured as self-governing, unincorporated life of the church. That's what they are. They're unincorporated life of the church. And once they hold property, they have trustees to hold the property for them. And it's not a new model. It's not an Australian invention. It's as old as, go back 1st century. If you look at the Book of Acts, how property was held by people as individual trustees. But you've got to take it further back to the temple law, actually, as set out in Leviticus, that property given to God was held by priests as stewards. The whole notion of stewardship. Stewardship is an early descriptor of what is actually then became the law of trusts. Property held for purposes, in our instance, for purposes. So we're purpose trusts. And trusts, as you all know, as very well-informed lawyers in this space, in the charity law space, are the foundational principle of property holding for charitable purposes. That's the fundamental DNA. This dual model continues to this day across all the different religious bodies, particularly for churches. The first formalised charity in the colonies of Australia was in 1817, which was established by an act of the New South Wales Parliament, the Bible Society of New South Wales. It was established under an act of Parliament. The mid-19th century, however, saw all the different state legislatures attempting to address the rapidly growing great problem of the growth of civil society. I'm leaving out the Indigenous story here, which I fundamentally know is really important, but I'm just talking about if you like, the Western legal framework that exists through this law of trusts in different states. So each of the state legislatures tried to actually address this question from about the mid-19th century. Great problem to have, the growing social welfare institutions and educational work that accompanied the establishment of all sorts of unincorporated life of the church entities. Not just churches, it was obviously other religious bodies as well, but we're talking about a Christian religious institution with this case, so I'll limit myself to those comments. South Australia, not surprisingly, led the way, 1858, with the Innovative Associations Incorporation Act. It was really a bit stop-start. It wasn't really sure that it would work, so it repealed it and had another go. But actually, it was really innovative, the notion that you could incorporate a body of it to do the work of it, an association. So that was really typically South Australian, very leading edge. But actually a little bit earlier, other states, beginning with Victoria in 1854, passed private acts of parliament to enable property to be held on trusts by church governing bodies. So this was a process that happened throughout the 19th century. The Recce Act of 1861 in Queensland, which is the act underlying this case, was an early version of that state legislation to enable the holding of property by charities and other associations and institutions. The unusual thing about the Recce Act was really probably unusual in a number of respects, but it was probably unusual in the fact that it wasn't replaced. All the other state legislatures had different goes at it, and they had sort of improvements and deal. But so the unusual thing about the Recce Act of 1861 is it's still there, although it isn't, as you probably know, because it's been repealed. But there's saving provisions that enable the existing several hundred of these entities to continue in Queensland, and that's the underlying sort of legislative and trust structure that underlies this case. And if you've read the Act, you know the Governor, on the advice of the Executive Council, could, on the request of certain named office holders in an unincorporated association, request that the letters patent be issued to declare those named office holders, either by individual name or their roles. I'll come back to that. But this is the key word. This is the magic sauce word. You have to remember it in this context. It's according to the rights, laws, rules, or usages of a community or institution. including religious institutions. They are the key words in the legislation, the 1861 Act, according to the rights, laws, rules, or usages of a community. So, have to say, you might not have heard of letters patent entities. If you've read this case, I'm sure you've come across it now. And for those of us practicing outside Queensland, we don't often come across them. We don't come across them in any other state, actually. But letters patent are not unique to Queensland. Letters patent in other states, particularly in the 19th century, you do find letters patent used to appoint bishops, for example, to be trustees of property for religious purposes. So the legal framework was this understanding of how trusts and entities and institutions worked, was actually a live thing across all states in the colonies. It wasn't until 1881 that the New South Wales Parliament passed the first Trust Property and Corporation Act, enabling the governing body of a church, in this case a synod, which is the name for a church governing body, to incorporate its own trustee corporations. And it included the vesting of property. Now, these are two key bits that are different. The Recce Act doesn't have either of them. It doesn't enable that church denomination to establish its own corporate trustees, and there's no automatic vesting of property. And these are 2 points that the judge covered. Okay, so second point, back to the Recce Act itself. The importance of knowing what the Constitution is. How do you know what the Constitution is? Now, the judge spent quite a bit of time. You must start, I won't go through all the detail of it. Read the case. This section is really, really interesting and very well worth reading. The wording of letters patent are different. They differ. The wording differs. So you have to actually read the actual letters patent because there are some subtle variations. Thanks to Miles McGregor-Lowndes, of course, the inimitable Miles McGregor-Lowndes, for making this point. So thanks, Miles. It's actually really important to look at actually what is said. So what the judge said in this case about Recce, the Recce Act and how it operated, and therefore was applied to the PCQ case. Properly construed, the Act provisions gives a corporation power to receive and hold and deal with property as trustee, as it said, for the uses. So the judge made it clear that the uses in that phrase, the magic source phrase, as I've referred to, is the trusts. The rest are purposes. So it's a simple differentiator. But the key bit is it's used for the charitable purposes of the unincorporated association in which the persons who are the corporation hold their offices. Does that make sense? That's absolutely a critical point to understand. So you go and have a look of the institution, the unincorporated association, and have a look at its constitution. Because that's where it'll say who makes the decisions as described well by my colleagues in how this is behind this case. But what is the Constitution? Is a really important point, and it's not always clear. In fact, in this particular instance, the PCQ didn't have a constitution as such. It had the letters patent. It had some statutory powers inferred to that incorporated body, but the rules and how it was going to be governed all sat outside. And in fact, the letters patent entity didn't have its own ABN. It wasn't registered as a charity. It had no activity, so it sort of operated like a bare trustee. So all the rules sat outside. But you say, well, where are the rules? How do you know? Very important. So what did the judge say? I can give you all the reference to this later, but I just don't want to take up time. So what did the judge say? However, in construing any instruments relating to such property, the court looks at the instrument as part and parcel of the whole machinery by which the church is kept together and carried on. That is, the terms of the consensual compact, which is the judicial name for the governing rules of an unincorporated association. The consensual compact is how it governs itself. And there are other High Court decisions. So, for example, Griffith, CJ, quoted in the McQueen case in 1909, which is quite a useful reference. It's the mutual relations and obligations of church members that are regulated by the terms of an agreement or consensual compact to which they are parties. That's where you find the rules of how. And going on, the judge says in PCQ, that agreement or compact embodies or includes expressly or by implication certain tenets of faith or common beliefs, as well as the form of government adopted for the regulation of the affairs of the individuals who comprise that church. It is these features, as well as the name and history, that serve to identify a particular church and to distinguish it from others. So the judge goes on. I won't go into all the detail. Have a look at the relevant paragraphs are really important. I'll leave some notes perhaps in the chat later. But essentially, a Recce Act corporation holds property on trust for the purposes of an unincorporated association. And it can have uses, the trusts and purposes sit in the constitution of. But interestingly, the Act itself doesn't require the Recce, the letters patent entity, I'll call it the LPE, doesn't require it to have a constitution. So part of the judge's commentary was, well, if it doesn't have it, where do you go and look for it? The constitution would sit. So there's a high degree of ambiguity, especially for those of you who are dealing with a number of these things. So in the case of PCQ, where do you go to find it? You find it in the basis of a union and the code, which is its own sort of constituent documents. That's where you go to find it. There's quite a lot of other explanation. The judge refers to McPherson's decision in Bailey, which is an important case. So, for example, in Bailey, McPherson says that the corporation fulfills its intended role, that is, of a repository of the property of the association, holding or acquiring that property for the uses or purposes of the corporation and for the religious or secular institution or body or association of persons by which the office holders and their successors are appointed, because they're the magic words from the Recce Act. So that's how it works. But for any different institution, if you have a look at it, they are actually quite complex, as the judge found, trailing through, well, what were the actually relevant constituent documents for this particular entity? I'll jump to the third question very quickly. The third question, if you as lawyers, because there are a lot of practicing lawyers in the room, an important question is to ask is the constitution that a particular organisation have, is it fit for purpose? Is it actually able to do people know how to use it? Does an organisation know how to run itself? Now, actually, in this case, it seemed pretty clear that it was. It was a very, very organised. It had all these other documentation. But often entities don't have a lot of background support. So the question, it's a very important question. So I think one of the takeouts here is that the constitution of an unincorporated association must be understandable and help actually with clarity of decision making. It must be fit for purpose. It must be capable of being understood and used. So one of the common themes with some of these circumstances, not just in relation to PCQ but other church entities, is the phenomenon that you'll find that there's almost invariably one person who understands how everything works. And they will drive. I'm not saying anything personally about the particular one in this case, but if those of you have had dealings with these unincorporated associations, there's always a person who's the repository of knowledge and gives comfort and direction to everybody. So my challenge would be to anyone involved in these entities is the constitution fit for purpose, and is it understood, and can it be used properly for? So the other question I'll throw out there, but I think I'd love other people to answer: has the Recce Act outlived its usefulness? Has it outlived its usefulness? It's repealed. It's much loved by those entities that use it. There are hundreds still using it, but is it two great limitations that it's going to lead presumably to more litigation? Are organisations going to be able to obtain judicial advice to get clarity? Is that really too clunky? Is there a sufficient lack of agency for entities to be able to establish own trustee corporations and actually to amend them? And anyway, I'll leave it there. They're questions that I think that are really interesting to get in the chat afterwards. Thanks. Thanks, Nav.
Thanks so much, Anne. Yeah, those are very, very interesting and thought-provoking questions, and thanks to all three of you for raising some really interesting points. I'm just going to check in on the chat. Does anybody have any questions for the speakers? You can also raise your hand, and I can unmute you if needed. Ian.
I just have a question mainly for Elizabeth, and that's around the duties issue. And I'm just sort of wondering whether maybe part of the reason for seeing a difference in treatment between like the National Safety Council case, where you get statements suggesting, you know, same rules for everyone, doesn't matter that it's a non-profit, might be, was the court looking here at particular breaches of duty? And I'm thinking, you know, for instance, Barnes and Addy sort of situation where there's knowing involvement or knowing receipt of property, you know, because I think the receivers were trying to argue that the financiers should hand, you know, assets back, or were not entitled to assets. So anyway, I guess my question is it because the court was just focusing on particular breaches of duty that might be linked to that we might not have as much of a focus on, well, were the office holders negligent, say?
So firstly, it is really hard to tell from the judgment because of the way it's organised, but you can see from the summaries of the arguments the judge gave that they actually ran the argument that it was outside, that the whole transaction was outside of scope of power, but there were about 4 or 5 arguments that sat underneath that, and one of them was very explicitly that in entering into this, the trustees had exposed it, so that has exposed the property to a substantial risk and had not weighed the pros and the cons. So there was very much a focus on that. Now, I didn't read an argument saying, well, you know, we should be prosecuting someone for personal liability, but there was very much this extent that you've acted outside your powers, therefore we're entitled to invalidate that. And that wasn't just restricted to the investment argument, and it wasn't just restricted to a pure power question. It was very much that, have you met the standard of the ordinary, you know, prudent business person? And that matches that. Yes, it's the different language, ordinary prudent business person, but generally in the case law, I've never understood a whole lot of difference between, like, there's a lot of congruence between ordinary prudent business person and a reasonable test under the Corps Act. So yes, in the facts of this case, you know, would you get this judge finding the same standard if it was litigation against the individuals? I think that is always something worth bearing in mind. Yep.
Well, I think then we will leave it there. We actually are pretty much out of time, but please join me in thanking our speakers for all of their sharing all of their expertise and knowledge. And I think they've given us a lot to think about in relation to this case and how it might apply to various organisations, it sounds like even outside Queensland. So thank you all. And just a reminder to everybody who is still online, that the CLAANZ, please note the dates for the CLAANZ conference next year, which is going to be held in Sydney, July 23 and 24. So soon you'll be getting more information about that, and you can certainly register for that. So thank you again, everybody, and we'll see you next year for more of these webinars.